This is Duke University.
Thank you, Judge. Well, now I'm looking at your bio here, and you've done so many things. So you went to college at Yale, and then it looks like you went right into the U.S. Army after that, and you came out of the Army after 2 years, and you ran for Congress on the Republican ticket from Virginia. I don't think that succeeded, but the ambition was there.
Well, I'll just pause for one moment there. I was 25 years old when I ran to Congress, and I left law school after my first year to run for Congress. And I got the Republican nomination. I was running against a 3-term Democrat, and he knew exactly what to do with me, because he had a big billboard. What is this 25-year-old kid running for Congress? What would you do if you had a big billboard? Well, he had a big billboard saying, "Send Satterfield back to Congress and Wilkinson back to law school." And unhappily, the voters complied with that suggestion. So it was the day after, I was talking to a television reporter and said, "Judge, how do you feel about last night?" And I said, "Well, I feel like I received an extraordinary mandate." He said, "What? You didn't get more than a third of the vote." I said, "I received a mandate to resume law school, and that's where I'm going."
Well, so we are the beneficiaries of that. Your opponent didn't realize how powerful that first year of law training is. Or he wouldn't have wanted even to bring up the fact that you'd had that extraordinary analytic training already. So then, back to law school. I didn't realize there'd been that break. Then you clerked for Justice Powell, as you mentioned. I think maybe you were his first law clerk.
Yes, that's right.
So that has its own challenges, setting up a chambers, particularly for a justice who was not a professional judge, but coming from private practice. That was something of a transition that the members of the current court, most of them, have not made.
And David, it was a funny thing with Justice Powell's relationship with his first group of law clerks. I mean, here we were, green and right out of law school, and 7 days out from having passed the Virginia bar. And I remember he was a senior partner of a major law firm, and he'd been dealing with other partners and very experienced associates, and all of a sudden the only assistants he had was a bunch of green law clerks. And I remember, David, we had this case, and it was a procedural due process challenge to a garnishment proceeding. And to resolve the case, you have to know a little bit about how garnishment works. Just the mechanics of it. And Justice Powell asked us some questions about it, and it pretty soon became clear to us that none of his 3 law clerks had the foggiest idea of how you went about garnishment. And his jaw just dropped. And it was like he said, he was too polite a man ever to say it, but his eyes told the story. "What good are you?"
And then you left the clerkship, and as many Powell clerks have done since, you went into law teaching, and you wrote a book on Brown to Bakke eventually. But then you left to become the editorial page editor of the Norfolk, Virginia Pilot. Now, how did that happen?
Well, I'd always, I'd spent some summer writing for editorial pages, and it just seemed to me that I had led, frankly, a rather sheltered existence, and I got out of my own little circle and bubble and circle of friends by running for Congress and learning about the district and being in politics. But I thought that it was very important for me to get out of what was really a sheltered, kind of a sheltered bubble, going to fine schools and good law school and the rest, but it's a fairly narrow slice of human experience. So I went to the newspaper as kind of, was the editorial page editor of the newspaper, and it was kind of, I looked at it as kind of a postgraduate degree for me. I love being able to wake up in the morning and if something bothered me, to just go in and write an editorial about it and let off steam. That was fun. But the interesting thing was to the degree that a newspaper has influence, it has influence not in talking about the grand issues of the nation, but by talking about intensely local concerns. And so what I enjoyed about the experience was going to a housing authority meeting and just sitting for 2 hours listening to the housing commissioners talk about things, or going to a planning commission meeting, or going to a zoning board, or hearing the different local governing groups talk about how they were going to deal with water rights and water supplies and everything. And if you sit through those meetings just for hour upon end, you really learn about what makes local government tick. And it was an experience that I just didn't feel like I could really get out of the path I was pursuing. And so I wouldn't give anything for that. And it's helped me with my time management skills, because you've got to get a newspaper out every day and write editorials every day under deadline. You know, I think that one of the greatest helps you can have is just in terms of really good management of time. And I think a lot of successful people have been able to develop that. I don't know that I have, but working under deadline every day helped me really with time managing my day. And it's a wonderful experience. I wouldn't give anything for it.
So then you went from the newspaper to the Department of Justice, where you were Deputy Assistant Attorney General in the Civil Rights Division, and you were there 2 years. And then you went to the bench in 1984, and that's the job that you've held for the longest period of time in your mature life, almost 30 years now. And my question, and I think a lot of the students in the room would be interested in, is just seeing that you tried so many different things. You tried to run for Congress. You were in the executive branch. Now you're in the judicial branch. You were in the fourth branch in the media. You taught law. You didn't practice law, but you did a lot of different things. And I wonder how that contributes to your, what you make of that, and also how you feel that it contributes to your judicial philosophy, that experience that you've had.
Well, I think it's important to ideally to have people with a broad range of experience on the bench, and I feel like I'm a better judge because of the experience in the executive branch of government, and because of experience as a law clerk and experience in the newspaper business and teaching school and being in politics for a number of years before going on the bench. And it convinced me that one of the most valuable things that judges can bring is a breadth of experience. And what I worry about with respect to the federal judiciary today is that we may not be getting, we need to have people who've had prior judicial careers as trial judges. We need to have people who are academics go on the bench. We need to have people with experience in politics and government. And it's essential that we have people with a background in private practice to serve on the federal bench. And it's this latter dimension of experience that I worry about. Because when I was working in the Reagan administration, one of the things we tried to do was to recruit distinguished private practitioners for the federal bench. And that was sometimes not an easy thing because there was such a disparity between the judicial salaries and what people were earning in private practice. And they were going into their top earning years in their 50s with children facing college tuition and law school tuition. And it was a hard financial proposition to persuade people in their early 50s with family obligations and children to give up a salary in private practice and go on the federal bench. And it became especially difficult when we said, well, you might have to look forward to a year and a half of a grueling confirmation process while you're filling out all kinds of forms, talking to the FBI and the ABA. And once you get through that, you've got to run the gauntlet of Congress. And meanwhile, by the way, you've got to put your practice on hold and sit there while your clients watch people take shots at you. And so, you know, David, we had some really, really good people in private practice whom I thought would make just superb judges. But it was hard sometimes to get them because of these obstacles. And I worry as the judiciary goes forward in the future, we simply have to be able to draw upon the ranks of private practitioners in order to maintain our links to the legal profession and an understanding of what lawyers go through when dealing with clients. And I do worry that part of the experience 15, 20, 25 years from now could be largely missing from the bench.
Now, we've talked a lot about law clerks and you and I being law clerks, and of course you've had so many law clerks, and your book, which we'll talk about in a moment, is dedicated to your law clerks. A quarter or more of our graduates will clerk for a judge and are very interested in that. And I'm wondering about your relationships with your law clerks, how you use your law clerks, what that's meant to you over time. Well,
it's probably the thing that makes, there are many things that make service in the federal judiciary gratifying, but having law clerks is probably the best part of the whole deal. You know, when it came time to dedicate my book, I wanted to dedicate to my clerks. So that'll give you a sense of how I feel about them. And I tease them. I said, you folks may not be sons and daughters, but you, at the very least, you're nieces and nephews. And you're part of my family. And to watch, it gives you such hope for the future of this country to have these remarkably talented men and women come in and work with you every day. And I learn at least as much from them as they do from me, because frankly, as they remind me in the gentlest sort of way, sometimes I can lose a little bit of touch with what's going on in popular culture and what 20-somethings and 30-somethings are thinking. And
you mean Neil Siegel has been your guide to popular culture?
Well, we won't get into Neil. He was a rascal. But it's this wonderful, wonderful intergenerational partnership. And there's there's a special quality to all kinds of friendships. There's a special beauty and quality to peer relationships, but there's also something really special about intergenerational relationships. We have so much to give each other. And I had intergenerational relationships with members of my own court when I first came on. I was so junior, and the senior judges of the court never once suggested that I call them by their first name. This was the only court in the country where that was the case. And at first I said, what is this? We're colleagues? And I couldn't refer to Judge Hainsworth as Clement or Judge Russell as Don. And I began to realize that those relationships were much closer, precisely because they were not on a first name basis. And during the 50 years that I knew him, Justice Powell never once came even close to suggesting that I refer to him by his first name. I can't even imagine in my wildest dreams addressing him as Lewis. And yet, these relationships are so much closer and distinctive because they're not on a first name basis and because there's a certain formality that characterizes them. And you don't come into chambers in the morning and say, "Hi, Judge, how you doing?" You know, there's just a special quality to these friendships that you form with law clerks, and you'll have 50 years of your professional life to do something else. So why not take 1 year off and just clerk and see the judicial system from the inside and see how judges work and how cases get decided? You'll have 40 to 50 years to do something else. But this is special. Don't let the time fly by.
So could we talk about how a case might move through your chambers?
Sure.
So let's say a case has come in and it's set for oral argument, and now I take it you might assign it to a law clerk to do a bench memo. You have the briefs as well, or am I right so far?
Absolutely.
And then what happens?
Well, the cases are sort of they're a little bit different. Some are about 10 times as challenging and perplexing as others. But I get the law clerk to write a bench memo from the briefs, and then if I have any questions, which I often do, I read through the briefs and with some care. And then I'll ask a law clerk I'll sit down with the law clerk and give the law clerk a very detailed outline of exactly what I want each thing to be, and I'll dictate several paragraphs and sentences and things that I want in the opinion. And then a draft will come back to me, and I'll warn the law clerk. I said, "You've never, ever seen anything like the way your writing is going to be scrutinized. You come through law school and undergraduate school, and all you did was hand in a paper and you got back a grade. But when you're in the process of writing judicial opinions, it goes back and forth from me to the law clerk an unbelievable number of times. It is not at all unusual to have an opinion go through 25 drafts before we release it. And that's because when you make a mistake, it's so very public, and you could harm human beings and litigants by doing so. And if you make a mistake, the whole world will point it out to you. The litigants will point it out to you. The press will point it out to you. Your colleagues will point it out to you. And maybe, heaven forbid, the Supreme Court will point it out to you. But it's a different experience for law clerks. I mean, we go over every comma and semicolon.
So let's just back up for a moment. So you've got the bench memo, and you've had a discussion with your clerk, and then you have the oral argument.
Right.
Yeah. So judges are often asked whether they think the oral argument makes a difference.
And you know, it really does. There's somehow, I don't know how this canard got going, that oral argument doesn't really matter, or that it's just for show, or that it's just a public relations gesture by the judiciary. That could not be further from the truth. It matters a great deal. Does it flip the result? Yeah, sometimes it does. You go in with one impression from the briefs, and by the end of that hour of oral argument, you're of a different mind. That doesn't happen too often, but you know, it happens maybe 15% of the time, but that's significant. It helps you write a better opinion for sure. And sometimes it may not flip the entire result in a case, but it may lead to a modification of the result in a case. It's really different from moot court. For one thing, the moot court cases are round little pebbles. It's like topiary. They're highly landscape, but you get to a real live case and it has so many rough edges you can't believe it. And the other way it's really different from moot court is, and this is what's the hard thing about it, is sometimes the plainly superior lawyer loses. And, you know, I can't tell you how many times I've had the impulse to write a letter to the losing lawyer in a case and say, look, I know you lost, but the bench really appreciated the argument, and you gave a great argument, and in fact, you gave the best argument. I've thought about writing that letter so many times, and then I thought, well, no, I'd get a letter back saying, yeah, Judge, that really is going to help me a heck of a lot when I talk to my client. So I've resisted penning an ode to a losing lawyer because lawyers have to face their clients afterwards, and we don't. But oral argument matters. And it's a different process from the briefs, because the briefs you want to explore it broadly, but oral argument, you really want to go for the jugular, and you want to keep that thread of your argument at all times in sight. You want to leave the bench with one indelible impression, and that doesn't mean that you don't answer the judge's questions, and it doesn't mean that you don't vary a little bit and adjust with the flow of the argument. It doesn't mean that you don't concede the weak points in your argument. But before every oral argument, think to yourself, somewhere in this case there's a winner for me. And that's the impression that I want to leave with the bench. And come back to it, and don't be afraid to repeat it. And as I say, you need flexibility and you need candor, but you also need to have an instinct for the jugular and know that a good advocate drives home the point. And what is it you want to leave in our mind when we leave the bench and go into that conference? And it's not a whole lot of things. It's one distilled point.
Now, I know in the Fourth Circuit, after the argument, but I'm not clear on whether this is after all arguments or just after each particular argument, the judges shake hands with the lawyers?
We sure do, and that's because sometimes things get pretty heavy in oral argument, and they are pretty fast and furious, and you grill somebody, and we have a hot bench, and you grill somebody, and the judge is relentless on the point, and so we worry a little bit. Well, we were so tenacious with that lawyer, the lawyer's going to think, well, maybe the judges have something against me or something. They are so tenacious. And going down and shaking hands with counsel helps to dissipate that. You go and you talk to somebody and you say with that handshake, look, I know you've been through a rough half hour, but there isn't anything personal about this. Now, I'm a great believer in the Fourth Circuit shaking hands with everybody after oral argument. Why is it that we're the only circuit in the country to do so? So I once set out to try to change that. And I asked my friend Ed Becker on the Third Circuit, I said, Ed, I want you to get your colleagues to come down and greet counsel after every oral argument. I said, your judges will warm to the practice. And several months later, he called and said, Jay, it's just not going to work. And I said, why, pray tell? And Ed said, well, Jay, my colleagues on the Third Circuit feel like all this shaking hands after argument is going to spread all kinds of germs.
There you go. That could be. So that's nice. So then you go back to you have a conference, you vote, the opinion is assigned, and it comes back to chambers, and now you're working with your law clerk, as you said. What is? Do you have a reflection on a good judicial opinion writing? Comparable to what you just said about oral argument. Is there what makes good writing from your point of view?
Well, there's so many different styles of writing. I think just clarity. Legal writing shouldn't be all that different from normal writing. I mean, no, that's a bad use of the phrase, from ordinary writing. I think probably the two greatest stylists on the Supreme Court were Hugo Black and Robert Jackson. And so there's no one template here, but Robert Jackson just had most extraordinary eloquence and the rest. And, you know, in the flag salute case, in the steel seizure case, just gives you chills to read it. But he was just a very lofty rhetorician at his best. Hugo Black, he came from the Alabama hills, and he never lost it, and was a brilliant stylist in his own way. And he was a United States Senator, and the writing had the raw power of a stump speech at times. But Black was a very literate and educated man. He was self-educated, and when he first came on the bench, he read the 100 greatest works of the Western world to educate himself. So you combine in a stylist with somebody who's just steeped himself in Homer and Thucydides and other books in order to educate himself, and you combine that with a hard scrabble existence in the piney woods portions of Alabama. And you get this extraordinary simplicity and clarity and power in a Hugo Black opinion. And somebody asked him once, I'll say, why do you write the way you do? And he said, I want to make sure that the folks at the Clay County Barbershop can take up this opinion and read it and understand what I'm trying to say. And so I think there's a good lesson in that. Maybe not the Clay County Barbershop, but some other place where you like folks and think we have, you know, maybe it's a Rotary Club, maybe it's but just some place where people who are not schooled in legal arcana can understand what it is you're trying to say.
So you write so beautifully and well, and you've put so much effort into it. And let's say you've written this marvelous opinion, and now there's a call for an en banc from one of your colleagues. You and I've talked about this before, so I think I know how you greet those calls. But how the en banc procedure? How do you feel about that?
Well, it may be necessary in rare instances, and the Federal Rules of Appellate Procedure provide for it in rare instances. I'm a believer that it has more drawbacks than virtues. For one thing, courts, those en banc rules were comprised with courts of 7 or 8 members in mind, and now the circuit courts routinely have 16, 17 judges. There's something that's much less of a judicial proceeding when you have an en banc proceeding with 14, 15, 16 people on the bench. That was why there was such a reaction to President Roosevelt's court packing plan, where the people had the sense legitimately that a court could at some point become too large. And I think that point is reached when you're talking about 14 or 15 people. I think it ties up judicial resources because those 14 judges hearing one case are unable to hear any number of other cases. And why should a case be reheard the second time when so many people are waiting for their case to be heard the first time? The opinions take an extraordinarily long time to get out. If the panel opinion is really all that wrong, the Supreme Court's likely to correct it, and the judicial process itself will trim back on it. And I think it's exacts, of course, cost in collegial relations, because the standard for going en banc is to say not that you just feel a colleague's opinion is wrong, but it's very wrong. It's almost like a clearly erroneous standard applied to your own colleagues. So I think this rule was passed in an earlier time. I think there are extraordinary costs to the proceeding. And yet there are times when uniformity of circuit law can be maintained this way. So I wouldn't say never, but I would say very sparingly.
So we've talked about the germophobic Third Circuit, and the circuits are all a little different from one another.
Yeah.
And they have kind of a different culture, and their geography is different, their sizes are different. If we all understand the affection and pride you have in the Fourth Circuit. What makes the Fourth Circuit as wonderful as it is from your perspective?
Oh, there's so many things. I think part of it is our traditions. I think part of it is the premium that the judges place on collegiality and not allowing, sometimes our debates get very heated, and you always have to remember that you want to disagree agreeably, and you don't want it to become personal. And I think we have really done a good job as a court from preventing our disagreements from becoming personal. And that's really important to what we do. But I think the Fourth Circuit's qualities really owe a lot to the character of this region and the character of the bar. Bar by and large is very professional, well-prepared, courteous, and I just love this section of the country, the Upper South and the Mid-Atlantic states. There's a great deal of professionalism, but there's also a great deal of respect for the traditions of the bar and the courtesies of the courtroom. But this is just a wonderful region of the country to sit on a court. I think another thing about the Fourth Circuit is the variety of its docket, and that is a reflection in many cases from the variety of its locations. We have some of the most rural and areas which have produced one set of cases, and then we have areas on the shore and on the water which can give rise to another set of cases, and then we have large metropolitan areas like Charlotte and Richmond and Baltimore which produce other kinds of cases. And because we ring Washington, in Northern Virginia and Bethesda, you have all kinds of cases dealing with vital questions of counterterrorism and national security law. But all areas of the circuit, from Cumberland Gap to the eastern shore of Virginia, have wonderful lawyers that you should never make the mistake of thinking because you went to Duke Law School and someone else went to Appalachian State that you're going to just walk over that person, because I tell you, it won't happen. Sometimes the person from Appalachian State is going to be mighty, mighty capable. And I'll tell you one thing, no matter how fancy your education, don't ever underestimate anyone.
It's a good rule. Can we talk about your book a little bit?
Sure.
Yeah, so this has just come out. I just have my copy, so I've not actually read it, although I've flipped through it. It has a most provocative title, Cosmic Constitutional Theory: Why Americans Are Losing Their Inalienable Right to Self-Governance. You had an op-ed in the New York Times yesterday, which I think is to some extent a summary in a way of the main point of the book, but why don't I let you describe why you wrote the book and what you're seeking to accomplish.
Well, you know, I was having the most fascinating time reading these theorists, and I was reading Brennan and Bork and Scalia and John Hart Ely and Richard Posner and the great luminaries of the law. And you think if you got Brennan and Posner and Bork and Ely and Scalia and others together, that you'd have the most exciting dinner party since Thomas Jefferson dined alone. And it was, they were absolutely fascinating. They were brilliant people. And I learned a lot from them. And yet, it seemed to me, in the end, when I was reading the most luminous minds in our entire profession, that they suffered from a common failing. And that was that they were providing intellectual cover and rationalizations and everything for judicial activism from the right and from the left, and that they were providing an aura of respectability to judicial misadventures, and that whether it was living constitutionalism or originalism, they suffered from this basic failing. And you know, people have different kinds of accountability, and politicians have electoral accountability, and business people have financial accountability, and judges are life tenured, but we have a certain accountability as well, and I would call it reputational accountability. And the creators of reputation are sometimes these great theorists and many of the academic centers of the country, but I thought that they were making it reputationally respectable to venture into areas where judges really had no business being, and that the judiciary was simply losing its stature in following these glitzy, brilliant, luminous men. And that a sense of self-restraint as embodied by people like Oliver Wendell Holmes and Louis Brandeis and John Harlan and Felix Frankfurter and Lewis Powell, would help right the balance. But it just seemed to me like some very brilliant and fancy and luminous people were leading the judicial culture badly astray. So I wanted to issue a cri de coeur, and that's what the book is.
You did, and your op-ed is called "Cry the Beloved Constitution."
Yes,
so
it's a cri de coeur. It's what it is.
So you have a chapter on each of the prevalent theories, one on living constitutionalism, one on originalism, legal process, and pragmatism. Mm-hmm. And in each chapter you do the theory of the justice of explaining why it has certain benefits and why it brings some clarity perhaps, and has those who follow that theory perhaps are able to handle certain kinds of disputes in a way that is beneficial. But then you always return to the point that there's no constraint in these theories. Is that
That's right. I mean, the theories are so loose. They let judges do too much of what they want to do, and they, have really provided academic respectability for politically driven outcomes from the right and left. And this is not what judging ought to be. And so, I thought, there's what can I say? There's a feeling now among Americans that institutions have lost their sense of self-discipline, and inebriate spending in the Congress is not all that different from ideological self-indulgence on the bench. And I believe Americans want to see a sense of restraint and self-discipline in their public institutions that is not wholly there. The question for any civilization is whether the sturdy virtues of the founders can be kept intact and respected by subsequent generations. And in some respects, we've improved on the American project and improved on the founders' vision by diversifying the franchise and by making more groups part of the American dream. In that sense, we have improved on what the founders did. But in another sense, we have not. The institutions of government in different ways, whether it be self-indulgent ideology or whether it be, as I say, inebriate spending or whatever, the discipline necessary for effective governance is failing us. And if there isn't some corrective, I think we as a country shall pay the price.
So would it be fair to say that your theory of your cri de coeur, your call for judicial restraint, that you see this as neither a position from the right or from the left, but
I think that's right. I mean, I think every judge is going to vote to uphold results that you may find personally displeasing. And if that doesn't happen to you every so often, you probably really aren't following the law. And there just time after time where I've voted to do things that, were I writing on tabula rasa, I would do differently. But I know that the great Supreme Court justices of the past century have had what Herbert Wechsler once called neutral principles of law that were applied consistently over an array of subjects. And sometimes the application led to conservative results, and sometimes it led to liberal results. But the point is, there was the higher satisfaction of this reverence for law and an understanding of what law really means to this country, and it's the importance that it has in preserving liberty and preserving order. And one of the things that struck me in just sort of thinking, I was doing a little essay for a book on Queen Elizabeth's 60th Jubilee, and I thought, you know, why did Britain and America stand so proud at the end of the 20th century? And a big part of that has to do with the rule of law. It's a sacred trust. You know, when the tyrants of the 20th century, these monsters like Hitler and Stalin and Mao, wanted to take over society, and we see other dictators trying to do that today. They go after 3 or 4 things. They go after the ballot and the free exercise of the franchise, and they go after free expression and the press, and they go after private property. But chief among their targets is the rule of law. They don't want independent courts. And you know, this is a sacred trust that we have here, and there ought to be a reverence for the law as the law. And that's what I'm trying to convey here, that there is just no more important lesson.
Judge, thank you for coming to Duke. Thank you for your service. It's a pleasure to have you here today.
Produced by Duke University. Online at duke.edu.